Thank you for joining me. My name is Lori Morgan. This is my employment law presentation for Business Law 101. Employment law is a broad scope of laws encompassing all areas of the employer-employee relationship. Employment law includes both federal and state laws that employees and employers must follow. The scope of employment law includes laws that mediate the relationship between workers, employing entities, trade unions, and the government. Government agencies enforce labor law: legislature, regulatory, or judicial. What situations are covered by employment law? Employment law issues run the complete range from discrimination and harassment at a job to unsafe conditions, but one thing remains the same. If your employer is violating a law, you have legal recourse. If you have been discriminated against due to pregnancy, gender, age, race, color or religion, national origin, a physical or mental disability, etc., or if you have been harassed or subject to a hostile work environment, or if you are not paid a fair wage for your hours worked, or if you have been terminated for forming or joining a union, or if you have been treated unfairly for requesting legitimate FMLA leave, seek recourse. Don't wait. If you don't know your legal rights in a specific situation, get legal counsel and learn what they are. What kind of people are impacted by employment law? People who are impacted include owners and employers, managers, supervisors, and employees. Employees may be defined as full-time, part-time, seasonal, at-will employees, or independent contractors. They may also be protected class employees. What types of businesses are covered by employment law? It depends on how many employees a business has. One or more employees are covered employers who must provide equal pay for equal work to male and female employees. 15 to 19 employees are covered by the laws that prohibit discrimination for protected classes. The business is required to provide equal pay for equal work. 20 or more employees are covered by the same laws as businesses with 15 to 19 employees. 50 or more are covered by the same laws as those with 20 or more employees, and in addition are subject to FMLA requirements. State and/or local employment discrimination laws may also apply. Important federal laws are broken down into the following 4 basic categories. This is a list of some of the most important anti-discrimination laws, as well as 2 very important compensation laws. In addition, 2 extremely important labor laws. And last but not least, health and safety. Major acts of employment law include the National Labor Relations Act, Family Medical Leave Act, Americans with Disabilities Act, Title VII Civil Rights Act, Age Discrimination and Employment Act. The National Labor Relations Act 1935 accomplished 2 things. It established the rights of employees to engage in collective bargaining and to strike against unfair labor practices. It also created the National Labor Relations Board. The FMLA Act of 1993 is a U.S. labor law requiring covered employers, 50 employees or more, to provide employees with job-protected, unpaid leave for qualified medical and family reasons for up to 12 weeks during a 12-month period, and up to 26 weeks for injured or ill military personnel or family members caring for them. The ADA was passed in 1990. It prohibits private employers, governments, recruiting agencies, and labor unions from discriminating against qualified candidates with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other employment processes. The ADA is only enforced for employers with 15 or more employees, but it's recommended that all businesses comply. Title VII prohibits discrimination in employment and hiring. Current protected classes include race, color, sex, creed or religion, national origin or ancestry, genetic information, age, veteran status, citizenship, and physical and mental disabilities. Any business with 15 or more employees must comply with Title VII. All should, regardless of size, as a best practice. The ADEA prohibits employment discrimination against persons 40 years of age and older. It applies to private employers with 20 or more employees, state and local governments, employment agencies, labor organizations, and the federal government. Case examples follow for the National Labor Relations Act, 1935, the FMLA Act, 1993, the Americans with Disabilities Act, passed in 1990, Title VII, Age Discrimination and Employment Act, ADEA. Information on a couple of ongoing issues are attached. Number 1, the COVID vaccine mandate of 2021. And number 2, the No Surprises Act of 2022.